Hi, this is Zach once again. On April 1st, the Supreme Court of the United States will decide whether convicted felon Donald Trump can, by executive order, strip the constitutional right of citizenship from children born on American soil. The case is called Trump v. Barbara, and its outcome could redefine what it means to be an American. Trump signed an executive order that directed federal agencies to deny citizenship documents to certain children born in the United States after the order took effect. Specifically, children whose mothers were either in the country without legal status or only temporarily, and whose fathers were neither U.S. citizens nor lawful permanent residents. Essentially, if your parents were undocumented or here on a visa and you were born in America after this order, the Trump administration says you are not an American citizen. Now, multiple district courts immediately blocked the order as unconstitutional. Those cases were consolidated and eventually worked their way up. In December, the Supreme Court agreed to hear the case, and a ruling is expected by the end of June or July of 2026. The plaintiff in the lead case is a Honduran woman known only as Barbara. She goes by a single name because she fears for her life and the life of her family, including her unborn child. If this executive order stands, her child, born on American soil, would not be an American citizen. Now, let's go back in time. The 14th Amendment of the United States Constitution, ratified in 1868, says, and I quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." End quote. Let's break it down even further. All persons born in the United States, subject to the jurisdiction thereof, citizens. That's the plain language. There's nothing in there about unless your mother was undocumented. The 14th Amendment was written in the aftermath of the Civil War to repudiate the evil Dred Scott decision of 1857, in which the Supreme Court ruled that Black Americans could never be citizens and had, once again I'm quoting, "no rights which the white man was bound to respect," unquote. The framers of the 14th Amendment wanted to ensure this could never happen again. They used the broadest language they could find on purpose. This issue has already been adjudicated by the Supreme Court 128 years ago. Wong Kim Ark was born in San Francisco in 1873. His parents were Chinese citizens who lived and worked in the United States. When Wong traveled to China to visit family and tried to return home to America, the US government refused to let him back in. They said he wasn't a citizen because his parents were Chinese subjects. The Supreme Court disagreed. In 1898, in a 6-2 decision, the court held that Wong Kim Ark was, and has always been, a citizen of the United States by virtue of his birth on American soil. The majority opinion stated that the 14th Amendment's opening words, "all persons born," are, quote, "general, not to say universal, restricted only by place and jurisdiction and not the color or race," unquote. The court said the only two exceptions to birthright citizenships were two extremely narrow ones: children born to foreign diplomats and children born to enemy forces in hostile military occupation of U.S. territory. That's it. Two exceptions. Not children of undocumented immigrants, not children of visa holders. Those two narrow exceptions. The Wong Kim Ark decision has governed American law for over a century. Every administration, every Congress, every court has operated under this framework. Until now. So what arguments does the Trump administration make? Their central claim is that the phrase, "subject to the jurisdiction thereof," doesn't mean what the courts have always said it means. They argue it refers not to physical presence in the United States, but to what they call political jurisdiction, meaning complete and direct allegiance to the United States. In their view, someone who is undocumented or here on a temporary visa doesn't owe the United States that kind of allegiance. Therefore, they argue, their children are not truly subject to the jurisdiction and are not automatically citizens under the 14th Amendment. They also point to a case called Elk versus Wilkins from 1884, in which the Supreme Court held that a Native American who was born on a reservation was not eligible for birthright citizenship because tribal reservations were considered sovereign from the federal government at that time. And they say that case proves that jurisdiction has always meant something more than just being physically present on American soil. And they claim that the Wong-Kim Ark decision itself doesn't settle the question of undocumented immigrants, because Wong's parents were legal residents with a permanent domicile in the United States, not people who were in the country illegally. But let's just start with the text. The 14th Amendment says, "All persons born in the United States and subject to the jurisdiction thereof." Undocumented immigrants are absolutely subject to the jurisdiction of the United States. They can be arrested and prosecuted. They can pay taxes. They are required to obey every single American law. The jurisdiction of the United States applies to everyone physically present on its soil. That's what jurisdiction means. The administration's reading of jurisdiction as some higher form of political allegiance has never been adopted by any court in the history of this country. Then there's the history. The framers of the 14th Amendment knew exactly what they were doing. During the debate over the Civil Rights Act of 1866, the blueprint for the 14th Amendment, opponents of the bill warned that it would grant citizenship to children of, quote, gypsies, unquote, and other non-citizens they considered undesirable. The framers heard those objections and passed the bill anyway. They intended broad, inclusive language. They knew non-citizens would benefit. And then there's the precedent. Wong-Kim Ark doesn't just speak to permanent residents. The majority opinion used sweeping language, calling birthright citizenship a foundational American principle rooted in English common law that dates back centuries. The constitutional accountability scholars filing briefs in this case argue that under the common law tradition the farmers drew from, virtually everyone physically present in a country, with the two narrow exceptions, was considered within the jurisdiction of that country. Finally, there's the practical argument. The 14th Amendment cannot be changed by executive order. New Mexico law professor Joshua Kastenberg has said if you don't like what the Constitution says, there is a process. You have to amend it through Congress and the states. That process exists for a reason. It's supposed to be difficult. The person in the Oval Office can't just override it. Now, in fairness, let's look at the strongest version of the counter-arguments, because understanding them is how we fight them. Critics of universal birthright citizenship argue that the drafters of the 14th Amendment were thinking specifically about newly freed slaves, not about global immigration patterns that didn't exist in 1868. They point to statements by legislatures at the time suggesting that subject to the jurisdiction thereof was meant to exclude people whose primary allegiance was to a foreign government. They also argue that the concept of illegal immigration simply didn't exist when the 14th Amendment was written. The United States had no immigration restrictions until 1875. So, they say, you can't apply a clause written before immigration law existed to questions about people who violate immigration law. Some conservative scholars also argue that universal birthright citizenship creates a perverse incentive, that it encourages what they call birth tourism, where pregnant women travel to the United States specifically to give birth and secure citizenship for their children. The administration's Solicitor General argued exactly this before the court. And they argue that other democracies don't grant automatic birthright citizenship the way the United States does. Germany, France, the United Kingdom. Many nations have moved away from pure jus soli, meaning citizenship by soil, towards systems that require at least one parent to have legal status. Here's the problem with all of those arguments. The Constitution says what it says, and the Supreme Court has interpreted what it says for over a century. The original intent argument cuts both ways. Yes, the framers were thinking about freed slaves, but they used universal language. All persons. And the Supreme Court in Wong-Kim Ark said those words are, quote, general, not to say universal, end quote. The immigration law didn't exist argument is actually an argument for Congress to act, not for a president to act by executive order. If the law needs updating, update the law, or amend the Constitution. But don't bypass both of those things. And as for birth tourism and bad incentives, the data simply does not support the idea that birthright citizenship is a major driver of illegal immigration. The vast majority of undocumented people in the United States did not come here to have children. They came here to work, to survive, to be with family. Ending birthright citizenship would wouldn't stop that. It would just create a permanent group of people born on American soil with no country to call their own. Think about what it would actually mean if the Supreme Court sides with the Trump administration. Children born in the United States would not be Americans. Their birth certificates would not prove citizenship. Their parents would need to provide documentation of legal status just to establish that their child belongs here. We would create a class of people born in America who are stateless, not recognized as citizens here, not recognized as citizens anywhere. Legal scholars warn this could affect hundreds of thousands of children every year. It would be the largest rollback of constitutional rights in modern America in history. And here's something important to remember. This wouldn't just affect undocumented immigrants. It would affect the children of visa holders, tourists, students, workers on H-1B visas, people here legally on temporary status. You could have a colleague at work whose wife is on a visa, and they just had a baby? Under this executive order, that baby might not be an American citizen. The Supreme Court ruling is coming. We can't stop it, but we can make our voices heard. Contact your senators and representatives, especially if they're Republicans, and make clear that you will not accept a two-tiered system of citizenship in the country. The 14th Amendment was a response to the most shameful period in American history. It said, never again will we say some children born here don't belong. We cannot allow a convicted felon to undo that. Please subscribe, share, like, and comment. Thank you for watching.